Maybe you just screwed up. Shame on you. To look me in the eye and just bold-faced try to fool me? I'm sorry. What did you just say to me?
It was loaded, Your Honor.
Sir?
It was not loaded, Your Honor.
You're looking at me and you just told me it was not loaded? Is that what this all is? A charade?
But no, Your Honor, it's not.
What I hear is you don't like being incarcerated. But these are violent crimes. You're looking at life imprisonment on each one.
Brat is now confronting two extremely serious criminal charges, each one carrying the possibility of a life sentence. Despite the weight of the situation, he made the reckless decision to lie directly to the judge during his hearing. The moment those words left his mouth, the judge's reaction was swift and intense, sending a clear message that dishonesty in court won't be tolerated. And frankly, it's hard to fault that response. What's especially troubling is the wave of letters from Brad's family, all insisting he's a good kid who simply made a mistake. But let's be honest, this wasn't a minor misstep. Brad held two individuals at gunpoint. That's not a misunderstanding or a moment of confusion. It's a deliberate, dangerous act that put lives at risk. To make matters worse, Brad's behavior in court showed no signs of remorse. His smug expression and dismissive attitude throughout the hearing made the entire situation even more difficult to witness. It wasn't just inappropriate, it was deeply unsettling.
I mean, this is about accountability about what happened that day, right? You took that man's stuff and you went to try and take money from his debit card. You remember that?
Yes.
And it failed, right?
Yes.
And then you saw this 22-year-old lady, Miss Brooks, with her mother. You knocked her to the ground and you tried the same offense again, right?
She wasn't with her mother, but yes.
Still a 22-year-old lady, still somebody that you knocked to the ground, put a gun to her head, did the same thing again, right?
Right.
And whenever all that takes place and the officers finally get going, their reports, which your lawyers had access to, and I'm assuming you've had an opportunity to review, say that you were going over 100 miles an hour in an effort to evade them, right?
I don't remember how fast my mom.
Definitely well in excess of the speed limit, correct? You're doing everything you could to get away from, right? Just like today, you're doing everything you can to try to make sure you get probation, as opposed to, I'm going to ask this judge to give you 15 years, right?
The parties have rested the presentation of evidence. The court has the pre-sentence report that has been submitted by the probation office and admitted without objections. Arguments by the parties. What are you asking for, please? State.
Judge, I think you know it's clear that I'm asking for the 15 years.
There's no argument, Your Honor, in reference to what he did to two innocent people or two innocent families. What you see in the PSI report, though, is that there really isn't any criminal conduct after or before or after that in reference to the legal system. You have marijuana use in the U.S. Army, but wait a couple of years and probably marijuana use is going to be illegal in most states. But he was discharged not honorably. So what do you do with a kid that doesn't know? And what we tried to do today is to try to present a little bit, and I don't know whether it's a cleaned up version or not, but basically he grew up by himself. Mom seems like a decent person, but mom had to be able to support herself, and all her life he's had no dad, no one, not even financial support in reference to him. We realized through the questioning of the state that he had some abuse problems in Maryland from family members who took advantage of him. And then in the middle of all this was ripped from whatever persons that he had some type of relationship in his senior year in high school and sent to the outskirts of Chicago. Even now, when he talks to the probation officer preparing the report, I think he was forthright in when he started marijuana, the synthetic marijuana, which is one time, which he says was at the date of the incident. But also what he was going through in reference to depression, anxiety, psychological and emotional, and asked, and which was probably one of the few times that I've seen expressed a need for treatment for these conditions. You could put him on deferred, and he's looking at life. You can put him on deferred for one, find him for robbery on the other, send him because of maybe what he's done in county jail, and I could then file for shock probation if he corrected himself, if it was robbery, and keep him on the hook after that in reference to probation. We've got people, the pastor here, Pastor Matthews, and conditions, and as this court knows, the problem is I guess a lack of parental, but then it's also the lack of young people today not knowing what a gun and everything else gets you in the road that it goes down. We're asking the court, if it's not deferred probation, that you would consider deferred and something with a lesser included, to give them a taste of TDC and maybe a ride on a bus to Huntsville for a little bit of time to know what it's really like when you commit an offense that's going to, I guess, affect you the rest of your life. And then see, hopefully, if he does follow the rules and regulations there, that he's given that second chance and put back on under your supervision, and also with the help of his family and his church.
While it's true that the defense attorney is simply fulfilling their duty, the strategy they chose in this case is raising eyebrows, and for good reason. Arguing that the defendant didn't know any better feels not only weak, but deeply frustrating. If the goal was to build a compelling case, why not explore more plausible motives, financial desperation, coercion, or emotional instability? Anything that might offer real context. Instead, the claim that he couldn't distinguish right from wrong feels hollow and disconnected from reality. That, let's be honest, approaching someone with a weapon and forcibly taking what isn't yours isn't a gray area. It's a clear-cut violation of the law and basic morality. That's something even a child understands. Everyone present in that courtroom could see through the argument instantly, and it's baffling that the defense didn't pivot to something more grounded. In fact, this kind of defense often does more harm than good. Rather than evoking empathy, it can make the defendant appear arrogant, like they believe a shallow excuse can wipe away the gravity of their actions. And when the crime involves violence, the stakes are even higher. There's no room for ambiguity or soft pedaling. The seriousness of the offense demands accountability, not deflection.
What the court finds most compelling is that in the commission of this crime, it's already been pointed out that you assaulted two people, and both of them were threatened and in fear of their life by you, who has no authority to do that. You don't take God's will into your hands. And when you have a loaded firearm, and it was loaded, wasn't it?
No, sir, it was loaded.
I'm sorry. What did you just say to me?
It was loaded, Your Honor.
Sir?
It was not loaded, Your Honor.
You're looking at me, and I'm about to sentence you and make a decision, and you just told me it was not loaded? All right, let me read the report to you. Maybe you just screwed up. Because, sir, this is your life. Underneath the Charger's driver's seat, you were in a Charger, right?
It's John.
On the floorboard, in plain view, was a dark brown Glock with a laser attachment, just like the lady said, underneath the barrel. The Glock had one magazine inside with 10 9mm rounds. Shame on you. To look me in the eye and just bold-faced try to fool me? Is that what this all is? A charade?
But no, Your Honor. It's not.
You assaulted a woman, didn't have to. You assaulted a woman, had a loaded gun. What are you bringing a loaded gun to robberies for? Unless you intend to use it, sir. And then the man in front of his children, his little children, and the 1-year-old may not ever remember, but the 4-year-old, I remember when I was 4, certain occasions that were traumatic. We all do. You're the source of that horror for that child. Plus, again, you have a gun, and they really didn't know it was loaded, but when you point a gun at somebody and threaten them, they're going to assume their life is a clock's tick away. You have the power, which our Creator doesn't give you. You forced it on fellow humans, God's creatures. As we want to bring this up, how religious. You've been going to church for a long time, but yet you are here by a cacophony, a product of bad choices that defy your education in high school, that defy your upbringing and church going, that defy military. All of those are methods of helping people to make the best choices they can make. And after all of that, you put multiple people in harm's way. And it's certainly doesn't go without notice that the victims in this case want to see the justice. One of them, at least, has expressed, you need imprisonment. I haven't heard of really a thing in your from this evidence here that isn't seen in so many people generally. I mean, nobody's got a perfect upbringing. It seems there are a lot of people whose parents, one or the other, or both sometimes, are irresponsible, but yet they seem to do all right. They seem to follow moral lessons. And your family here, look at all these letters. They seem to be good guiding lights, but they don't know really the truth of your long-lasting decision to use drugs. A third of your life has been drug usage, a third. And they have never seen the Mr. Hyde side of your Dr. Jekyll. I know him to be a kind, loving, and intelligent young man. But you were almost a daily drug user that certainly tricked the people living in your house. They didn't know about it. And then to the probation office, you said you blamed your actions on smoking cannabis and synthetic marijuana. Your actions are based on poor choices. Drugs are out there. They're always out there. There's always a temptation on the dark side, but it's always good versus evil. But you were brought up in knowing the differences and choosing good versus evil.
At last, a judge stepped up and refused to let a tired narrative slide. The familiar refrain of, he's a good kid who didn't mean any harm. This time, that excuse didn't fly. When you examine the facts, the story simply doesn't hold water. Yes, his family may genuinely believe in his character, but belief alone doesn't erase the reality of what happened. Good kids don't suddenly decide to commit armed robbery. That kind of crime requires forethought, intent, and a conscious decision to inflict fear and danger on innocent people. The impact on the victims goes far beyond stolen possessions. These individuals now live with the emotional aftermath, heightened anxiety, fear of public spaces, and a lingering sense of vulnerability that can follow them for years. And yet, the defense continues to push a narrative that paints the defendant as naive or misunderstood. That approach doesn't just fall flat. It risks minimizing the trauma experienced by those who were targeted. This is precisely why the judge responded with such force. The courtroom isn't a place for sugarcoating or sentimental spin. It's where accountability is measured against the harm done. The judge's firm stance wasn't just about delivering a sentence. It was a statement. Excuses don't undo violence, and sympathy must never overshadow justice. It's genuinely refreshing to see a judge cut through the noise and focus on the facts. The defendant's current situation isn't the result of bad luck or unfortunate timing. It's the direct consequence of his own choices. And that's a truth the legal system must uphold. So here's the real question. In cases involving serious violence, should judges weigh emotional appeals from family members, or should their decisions be rooted solely in the nature and impact of the crime? It's a debate worth having, and one that speaks to the heart of justice itself.
There's nothing in the environment I see here that doesn't cause you to have made a mistake and fix it immediately. Do right from wrong. I watched his grandmother helped raise him in the church and instilled in him the love of God by taking him to church on a regular basis. He possesses compassion and love for others. The police reports of these two cases don't say that. You made horrendous choices, and in choices, bad choices, you have to pay for the consequences. Good choices, you get to enjoy success and celebrate. But here, this is no time for celebration, because I see a life of poor choices that has been wasted up to now, for the most part. What I hear is now what's changed is you don't like being incarcerated, which is a smart move, because unless you're sociopathic, I don't know who would. But these are violent crimes. You're looking at life imprisonment on each one, sir. And they're two separate crimes. So those could be added one to another under law, because you can't package a deal when you commit multiple crimes. You don't pay for less. Each bad choice or crime has its individual consequences, because there are individual acts of individual victims. Here, your attorney has fashioned with the state, has fashioned a limit where you have reduced your exposure for two violent first-degree felonies from life imprisonment to a maximum of 15 years in prison. And there's a big difference between 21-year-old and 17-year-olds who are in here. You have finished high school, you have been in the military, thereafter you made these poor choices. I just wish you could have listened to some of the role modeling earlier, because the genie is out of the bottle. You can't put the genie back when you commit a crime. You can't undo the wrong. You can't go to the victims and say, undo the trauma, please. Even in the worst occasion here, if you're sent to prison, you would be out well before you're 30 years of age, after essentially ruining the lives of at least two sets of people. Because I know what is told to me. They wake up with the horror of this experience their whole life, because they are not in control of their life. You were in control, and that's not the way it's supposed to be. We're all in this together. Live honestly, harm no one, give each person their rightful due. That's everything about law, and that's everything about religion, all wrapped up in those three concepts, which all three were shattered here by your actions. All right, I'm going to find in each of these cases you have pleaded guilty voluntarily. You were mentally competent to do so. You understood the consequences of pleading guilty. There was sufficient evidence supporting your guilty pleas from State's Exhibit 1 admitted in each of these cases. To support your guilty plea, to find you guilty beyond a reasonable doubt, I now find you guilty beyond a reasonable doubt in each of these cases. And I am following the agreements. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 15 years on each case, to run concurrently. The judgment shall show an affirmative finding that a deadly weapon, namely a firearm, was used in the commission of each of these crimes. Anything else?
No.
We are in recess on this case. No,
Oh, they just left.
there was, and a third case is pending. I have just dismissed that case.
Thank you.
So, the young man, once described as a good kid, has now been handed a 15-year prison sentence for 2 separate counts of aggravated assault involving a deadly weapon. While that's no small punishment, some observers are questioning whether it truly fits the severity of the crimes. Considering he was staring down the possibility of life behind bars for each charge, this outcome feels like a significant reduction, and to some, even a break. What makes this case even more surprising is what happened during the hearing. Despite lying directly to the judge, a move that could have easily derailed the plea deal, the judge still chose to honor the agreement, but not without first delivering a firm and pointed lecture, reminding everyone in the courtroom that accountability matters. The sentence itself carries weight, but it also reflects a measured approach, one that balances justice with the possibility of rehabilitation. The 15-year term will be served concurrently, meaning if the defendant maintains good behavior, he could be released before reaching age 30. That's a rare second chance for someone convicted of violent crimes. It's not just a sentence, it's a window of opportunity. Whether he uses it to turn his life around remains to be seen. This case raises a deeper question about how the justice system should respond to serious offenses. Was the sentence firm enough to reflect the trauma inflicted? Or did the judge lean too far toward leniency? It's a conversation worth having, and one that speaks to the delicate balance between punishment and redemption.